Welcome, Member Forge. If you're available for a mic check, will you please unmute?
Morning, how are you?
Doing all right. How are you?
I'm fine, thank you. And here's me on video.
Your audio sounds great. I see you on video. You're all set.
Thank you.
Good morning. Guess we're not on yet.
Good morning, Member Chan. You're 2 steps ahead of me, but welcome, welcome. I hear you and see you.
Terrific. Okay, so I'll stop video for a while until we get on.
Yeah, you've got a little bit less than 25 minutes to go.
Okay, thanks. I'll mute and stop video. Thank you.
All right, thank you. Good morning, Carl Sonnet. I hope I said that correctly. If you're available for a mic check, will you please unmute?
Okay, I'm unmuted.
All right, I hear you loud and clear.
Okay, can you see me as well?
I can see you as well. That was going to be my next question. You're all set. And
Perfect.
it and is
All
Sonnet
right.
how I pronounce your
Fine.
name?
It's Sonny, it rhymes with Bonnie.
Okay, thank you.
Okay, so it's Carl Sonny.
Carl Sonny, you got it.
Had a little difficulty signing in here.
I understand.
Now that we've confirmed, can I mute myself and stop the video for a while?
Absolutely. We've got a little bit less than 19 minutes to go, so feel free to stretch, do whatever you need in that time frame.
Okay, great. And on the agenda, it looks like I'm up pretty soon, but I didn't know if yesterday kind of affected today's agenda.
I think we're right on course for today.
Great. All righty. Good. Thank you.
You're very welcome.
member designation pop up? Thank you. Yeah, they're both on.
Okay. Good morning. So
Good morning.
the webcast is ready.
WebEx is ready to go.
Thank you. Good morning, everybody. My name is Dr. Larin. I'm the president of the Dental Board. Today is Friday, February 6, 2026. This board meeting is being held via teleconference with the disclosed in-person location available for board and public member participation. For all those who wish to participate online, please log on to the WebEx website provided on the posted agenda for this meeting. Instructions to connect to the meeting are provided on the agenda. During each call for comments from board members and speakers, we will ensure that all comments that can be accommodated are heard before proceeding with the agenda. This is an official business meeting of the Dental Board of California. The board welcomes public comments on any item on the agenda, and it is the board's intent to ask for public comments prior to the board taking action on any agenda item. Please be mindful of the words and tone you use when sharing your thoughts. We understand that issues discussed here may be deeply personal or frustrating, especially when we find ourselves on opposite sides of an issue. But even in disagreement, we ask that everyone engage respectfully. Let's aim for dialogue that is constructive rather than contentious. Please remember that every process, discussion, and decision undertaken by this board is grounded in our mission to protect consumers. That remains at the heart of all we do. The DCA moderator will explain the process for providing public comment shortly. For individuals participating via WebEx, when called upon, the moderator will give you individual permission to unmute themselves, and they will have 2 minutes to make public comment. The moderator will audibly announce when 30 seconds remain to conclude the public comment. After 2 minutes have lapsed, the individual will place back on mute. Only one public comment per agenda item is allowable per attendee. We ask all speakers to please stay on topic and not repeat testimony already provided. If you agree with testimony already provided, please just state your name and that you are in support of any comments previously provided. I would like to now ask the DCA moderator to please explain how public comments will be taken during this meeting.
All right, folks. When the time comes, we'll be showing a visual on the screen exactly like you see right now. We're going to ask people to raise their hands, and you can do that by pressing the hand button at the bottom of the screen. For our dial-in users, you'll need to dial *3 to raise your hand. And for our mobile device users, you may need to hit the ellipses button. That's the ... in order to find your hand. Back to you, Madam President.
This meeting is called to order. There are 2 board members participating in this meeting remotely. Each board member participating remotely must disclose whether there are any other individuals 18 years of age or older present in the room at the remote location with the board member and the general nature of the member's relationship with any such individuals. Dr. Forge, is there anyone 18 years of age or older present in the room with you at your remote location?
No.
Thank you. Dr. Chan, is there anyone 18 years or older present in the room with you at your location?
No, there's not. Thank you.
Thank you. Board members participating remotely are reminded that they must visibly appear on camera during the open portion of the meeting. If the remote member experiences any trouble with visibly appearing on camera, the member shall announce the reason for their non-appearance when they turn off their camera, such as due to challenges with internet connectivity. I will now ask the board secretary to please call the roll. Mr. Dearkin?
Good morning. This is John Dearkin, Board Secretary. I will now call the roll. Chan?
Chan here.
Chan present. Chang?
Chang present.
Chang present. David?
David present.
David present. Dearkin is present. Felsenfeld?
Felsenfeld present.
Felsenfeld present. Forge?
Forge present.
Forge present. Graywell?
Greatwell present.
Graywell present. Larin?
Larin present.
Larin present. Medina?
Medina present.
Medina present. Olage?
Olage present.
Olage present. Takur?
Takur present.
Takur present. Badr Hobley?
Badr Hobley present.
Badr Hobley present. You?
You present.
You present. We have a quorum.
Thank you, Mr. Secretary. We will now move on to agenda item 22, Board President's Report on Closed Session Items, page 110. The board met in closed session and granted one petition for consideration. Is there any board member discussion? Seeing none, is there any in-person public comments? Seeing none, are there any public comments from individuals participating via WebEx? DCA moderator, please facilitate the line.
All right, WebEx, now is the time to raise your hand if you wish to make a comment on the closed session update. You can do that by tapping the hand button at the bottom of the screen. Dial-in users, dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few more seconds to see if we have a request for public comment. Seeing no request, you wish to continue with the agenda?
Yes, thank you. Agenda item 23, presentation of Attorney General's annual report on accusations prosecuted for Department of Consumer Affairs client agencies, Business and Professions Code, Section 312.2, January 1st, 2026. Carl Soni, Senior Assistant Attorney General, Office of the Attorney General, Department of Justice, will be presenting this.
Good morning, President and members of the board and the public. My name, as indicated, is Carl Sani. I'm the Senior Assistant Attorney General of the licensing section of the California Department of Justice. Ours is one of two sections that represents the Department of Consumer Affairs in various matters. We represent about 24 agencies within the department, including the Dental Board. We also represent agencies outside of the Department of Consumer Affairs. Jump to the next slide, please. And one more slide there. Thank you.
Yes.
So this morning, I'm going to talk about the work of the licensing section generally, and then specifically about the Dental Board work that we have done this past year, our past fiscal year, in our last report. So next slide, please. So the origin of this report, called the Business and Professions Code 312.2 report, went back to a law passed in 2015, SB 467, the purpose of which was to require the Department of Justice and separate legislation that dealt with the Department of Consumer Affairs and the Office of Administrative Hearings, all to report on their case processing with the goal of tracking and improving case processing times following consumer complaints. The first report was prepared in 2018, reflecting the fiscal year 2016 to 2017. And this past year, that was our report was the 9th annual report, and it reported on 36 agencies within the Department of Consumer Affairs. Again, about 24 of those are represented by the licensing section, and the remainder, the medical board and some other agencies, are represented by the health quality enforcement section. Next slide, please. So how is the data that we are reporting on collected? Well, we use a software system called ProLaw as our case management system. And that case management system allows our attorneys, and there's over 100 in legal professionals in the licensing section, to monitor and track and put in milestones for various major events in any given case. We have in total about 200 ProLaw users, which include the attorneys and paralegals in the licensing section, as well as the attorneys and paralegals in the health quality enforcement section. So each case is opened when we receive a referral from a client agency such as the Dental Board. The investigative material is put into an electronic file, and then we start tracking the movement of the case from the inception all the way to the what we call the adjudication of the case, when the work of our attorneys at the Department of Justice is complete. Eventually, before the report is prepared, we actually have paralegals twice a year audit the data to make sure that all the data that is supposed to be in each case file is in fact in there and that it is correct. And then it is summarized based on our fiscal year and then consolidated into the report that is before you. Next slide, please. So this is just a general slide on the work for the Department of Consumer Affairs over the last 2 reports, and it shows that it's fairly stable. We saw an increase in the number of referrals that have come into our office. This is sort of the post-COVID work. There was a decline during COVID, and it's now pretty much restabilized to essentially pre-COVID levels. Next slide. So now we go into the work specifically that we have done for the dental board. And in this slide, what it shows is that 2 years ago, we had received 95 referrals from the dental board for accusation matters. Those are disciplinary cases. This past fiscal year, we saw a significant increase up to 141. And I would, just commend the staff and investigators at the dental board, because that shows a lot of effort going into examining, investigating, and then ultimately referring matters to our office. And again, that's something that we obviously enjoy seeing. It shows a very aggressive and effective enforcement department at the dental board, and really just quality investigations. What is interesting is, even though you saw the number of referrals increase, the matters rejected, which we occasionally do, was only 2 in each of the 2 fiscal years, which is a pretty low number. They can be rejected for any one of a number of reasons. I personally had a dental case many years ago where it was rejected because before the matter was filed, the gentleman dentist passed away. And so those matters are rejected and returned to the board. Next slide. Okay, this is further investigations. So if we receive a referral from the dental board and we examine it and we find that there is a need to, establish better evidence or more complete evidence on any one of a number of grounds, we can request that there be further investigation. Sometimes we may request a supplemental expert to look at one aspect of a referral, or maybe it's to identify witnesses that are no longer at the addresses that were provided. In any of those situations, we request further investigation. And we saw, a pretty actually decrease in the number of further investigations. And given the fact that the number of referrals actually increased over these last 2 years, that shows that the quality of the investigations that we received is actually improved. So that's a point to commend the staff of the dental board. Further investigations received increased. That means that it might have taken 6 months to get additional information or an expert on board. And once we get that information, we note it in our file. But those often cross fiscal years. And so this is, given the low numbers of 11 to 13, I don't view to be that significant. Next slide. And this is where we see the volume of the actual accusations that are filed. An accusation is filed. First, we get the referral from the client, from the dental board. We then examine all the evidence, and then we prepare a charging document called an accusation, which is the parlance that we use in administrative cases for the charging document, the complaint, so to speak. And after we have prepared that, we send it to the client for its review. And if they have, they concur that the facts and our document is proper, they sign it. The executive officer will sign the accusation. The moment the accusation is signed by the executive officer, it's deemed to be filed. And so we saw, again, this significant increase over the last 2 years. Again, that shows just an increase in enforcement work that obviously we like to see, and is consistent with what we hope to see post-COVID from a lot of agencies. The dental board has done an excellent job. Next slide, please. This shows accusations withdrawn. Really nothing significant there. Accusation matters adjudicated. So we saw 52%. So what does it mean when an accusation matter is adjudicated? What we're reporting on in this number is the event that makes the matter complete from the perspective of the Attorney General's office. So it's adjudicated when we have submitted the matter to an administrative law judge for decision. It doesn't mean that the final decision is the adjudication. It is the time when our work has complete, and it's then with the client. The board will review the proposed decision by the administrative law judge and will either adopt it, modify it, or reject it and send it back for further hearings. But in this case, it's really reporting on when our work is done. Next slide. Now, one of the things that the legislature appears to have been most interested in is tracking various intervals in the prosecution of our cases. And so this data here refers to the time from the receipt of an accusation referral to the time when an accusation is filed. And my personal goal is to see these, usually these matters filed within 90 days of the referral. And in this case, we saw 2 years ago, 76 days for 60 matters. And in this past fiscal year, 77 days, which is, from my perspective as the leader of the section, is very good data. Accusations filed after further investigation, 111 days, 91 days, which shows, on the surface that it appears that investigations that we ask for additional work on are coming back to us swiftly, and therefore there's a shorter delay between the time when we ask for that and the time when the accusation is filed. Next one. One of the key aspects of our work is to determine whether or not a given case can be settled, or whether or not there's going to be no response to the filing of an accusation, and therefore the respondent, which is equivalent to the defendant, is in default. So from the filing of an accusation to settlement is one of our key components that we measure. And 2 years ago, it was 289 days. And this past fiscal year, it was 260 days, which is an improvement, a 10% decrease in the number of days to settle. So when we get settlement terms, we really try to work at the client's direction to resolve matters so that they need not go to hearing. And that is one of the most effective tools, because we try to resolve as many cases as we can. I don't know the precise percentage that we do for settlement, but it's the vast majority of our cases are resolved by settlement. Default means that we serve the accusation and we provide 15 days to 20 days to see whether or not the respondent is going to answer the accusation and request a defense and request a hearing. If they don't, it goes to default. And this 2 years ago, it took 97 days to get the default processed. This past year, it took 161 days. I'm not sure exactly what is going on with those cases, but even with that, the cases are being resolved even by default, within a few months after the filing of an accusation, which is very good. Next slide, please. So the other interval the legislature wants us to examine is the time between the accusation being filed to when a hearing is requested and the hearing date received to the hearing commence. So these are two different intervals. So after an accusation is filed, we will get a notice of defense. There often is then a period of discovery that transpires between the parties. And then there often, if the other side is represented by an attorney or individually, they will work with us to set a hearing date. So this measures how long between the time when the accusation is filed, that is signed by the agency to when the hearing is actually requested. And in both cases, we see it roughly, 135 days plus or minus 1 day over the last 2 fiscal years. That's, from my perspective, good, because it means that we're negotiating, providing the evidence, often that the other side will want to have their experts review it. So those are very, I think, pleasing intervals. Hearing date received to the hearing commenced. This is when we request a hearing of the Office of Administrative Hearing to when the actual hearing occurs. And 129 days is actually, I think, very good. That's roughly, 4 months, which is actually pretty short from my perspective. And so if you add those intervals up, it shows basically a steady amount of time of 263 days, 268 days for the time where the matter is originally filed to when it actually occurs, when you add up those intervals. Adding those intervals can be a little bit of a mixed bag. I just want to caution people, because sometimes there can be a hearing can be filed and requested, and then the case may be settled and the hearing doesn't actually get commenced. So this is a little bit of a mix-up of, or not a mix-up, but I say there's some apples and oranges going on here. These are not strictly the same cases that are being measured. Next slide, please. So the work of our office for the past many years is to carefully measure all these intervals and find ways that we can improve them. Licensing actually has a data manager that we use to analyze and track everything that goes on, who also assists in the preparation of our reports, because our ultimate goal is if we can make improvements in each of these intervals that were just mentioned, we can shorten the overall time between the time when we receive a case and when it is finally adjudicated. The goal here of getting all cases resolved within 18 months from the filing of a complaint with a department and getting it adjudicated is a challenging goal. But if you can't measure it, you can't see what needs to be improved. And we actually have seen significant improvement over the past 6 years that I've been in my position. Agencies also vary. So if you look at that whole report, you'll see a lot of variety in the data between agencies, and that is usually attributable to a lot of changes that exist between agencies, different laws that mandate different processes. So it's never, in my view, a good idea to simply compare one agency to another, because they're just agencies just simply differ. And one of the final considerations in evaluating all this information is speed versus due process. So obviously, the goal here is to improve our speed that we resolve cases, and which we actually have done over the past several years. But there's also an aspect of due process that can't be avoided. So when a respondent appears in a case, they have a right to see all the evidence and to evaluate it, and they have a right to retain an attorney if they, at their own expense, if they choose to. And that process of discovery, especially in more complex cases that involve expert testimony, such as dental board cases, which often involve experts, we have to allow for the other side also to retain their own experts. So that due process kind of runs in a little bit of tension with the goal of speed. But we believe that we are seeing in the work of the dental board really generalized improvement. And I'm really pleased with the work that we are doing for the dental board. Very pleased with the staff and the enforcement arm of the dental board. And it is a pleasure to present this data to you this year, as I have done in the past. Thank you.
We'll let the board members sit down there. Let's see. This material, some of it is in your book, in your handbook for today, and the presentation will be posted on the website. Pardon? I'm gonna, Are there any
Thank you.
questions from board member? That's the next.
Robert David. Having said that it's difficult to compare different healthcare licensing boards, I'm just kind of curious. Maybe let's use the medical board as an example. Accusations filed to settlement, ours is 260 days average. What's the med board's?
I don't have that before me, and I don't represent the medical board.
Really?
Yeah, no.
The health quality enforcement section, which is our sister section, represents the medical board, the board of psychology, and other agencies.
Okay, I guess I'm just trying to, even if there's not an apples to apples, how do we compare the 260 days with other healthcare licensing boards?
I don't think you really can. There's a lot of different considerations that goes into every case. Cases that are agencies that may usually be referred to us that don't require expert testimony may go faster.
One. 151.
And agencies that have some additional complexity may take longer. I don't want to select any agencies, but I will tell you, having done this for the past 6 years, it's I think the data that needs to be focused on is specifically for the dental board. Dental board has statute of limitations. Some agencies don't have statute of limitations. There's just a lot of different components that goes into evaluating the speed of a case.
Fair enough. Thank you.
Are there any, yes, Dr. Vanderholt?
Hello, board member Vader Hopley. Thank you very much for the data. So out of curiosity, how many staff do you have on your team?
In the licensing section, we have about 115, give or take, of attorneys and paralegals who work on the dental board and all of our other client agencies.
So it's adequate.
Oh, we're always hiring.
Okay.
So we are actually in the midst of hiring right now.
Thank you.
Any other board questions?
Not a question, just a comment that the medical board data is in our packet, page 141, I think it is. Yeah, page 141 has the medical board, dental hygiene, and dental board information. Thank you.
Thank you, Dr. Thakur. Any
Madam
other
President, I have a
questions?
question. And an observation. Thank you, Mr. Sani, as our agencies work together to protect the consumers of the state of California. Oh, this is John Deerking, by the way. We have regulatory and licensing functions, and the big piece here, which we rely on for the Attorney General's office, is discipline cases. It's very important for several reasons. We meet our common objectives, especially under CPEI and protecting consumers of the state. And my observation, and one of the big helps, is perhaps settling these cases, as you indicated, prior to ALJ hearing. It provides certainty to the licensee and the respondent. It provides, in my view, adequate protection, typically for the consumers of the state of California, because the terms and conditions are pretty standard. We have guidelines that are usually indicated, always indicated, because we receive a copy of not only the memo, but the proposed stipulation, which then is reviewed by the board. Some of these instances that give rise to discipline in the first case are various. Some of these crimes are or acts, the underlying acts that give rise to an accusation or a statement of issues are incidents or crimes or acts of moral turpitude. Another big section is substance abuse. Now, arguably, crimes of moral turpitude are more difficult from which to rehabilitate, because unlike substance abuse, we don't have daily metrics that we can use to evaluate, like biological fluid testing in substance abuse cases. When a case goes to the ALJ for a proposed decision at the hearing, what we very often see is a more developed history of an individual licensee involved in the underlying misconduct. And that usually includes aggravating and mitigating factors. And sometimes there's quite a robust discussion of that. That really helps facilitate a decision in some of these cases. Now, it gets a little trickier because when we see stipulations offered up for consideration, we see sometimes something more on a summary side and something more on a narrative side. Now, I defer, especially in cases involving substance abuse, a more detailed explanation, which sometimes I do not see in these memos, and sometimes we don't even get the underlying accusation or statement of issues that accompany the proposed terms and conditions of probation in these cases. So my question is, what can we do to facilitate a more comprehensive understanding of the rational basis for which the terms of the settlement, which would then be agreed to by the respondent or licensee, how can we get that in our hands as a tool to evaluate some of these cases, especially when there's sometimes a significant departure from guidelines?
And you're posing that question to me?
Yes, Mr. Sani.
It's a tricky question for me to answer because the process of settlement usually involves a dialogue with our client representatives in which we have a discussion regarding the terms and conditions that are being offered. When we provide the memo, a recommended a letter to adopt a settlement, there's also a desire not to provide too much information such that if in fact the board were not to adopt the settlement, it has already heard more evidence that really should properly be the subject of a hearing. So we really try to characterize with the value of the settlement to the board, and we do that so that we can facilitate the adoption of a settlement. But there's always that type of tension where we're not going to try the case, so to speak, to the board when we're doing a settlement. We have to be mindful of the interests of the respondent in case the settlement is not agreed to.
May I follow up, Mr. President? Let me give a concrete example, if I may, Mr. Sani. Sometimes, very often, we see, for example, letters of support or recommendations for the respondent licensee. That is specified then in the memo. But very, very often, without seeing the documents themselves, like you're saying, there's a tension going back and forth. So my understanding, what I'm hearing is, in the opinion of the DAG who's working the settlement, he, she, or they are providing enough information by which we can make our own rational decision in carrying out our duty to protect the consumers of the state. And that should be reflected then in the terms and conditions of settlement in the stipulated agreement. Very often, these letters of support do not indicate that there is an awareness on the part of the author or writer of the support letter as to the underlying misconduct. And in point of fact, some of these that we have heard about in the memo are rather aged. So we don't know the purpose for which it's being offered. And in this case, if there is an act of accusation or statement of issues, then of course, that information would be very important because then it helps us facilitate our decision. So my question is it possible? Can we move forward indicating if there's a letter of support that and if there is not, my understanding is that case law tells us that these support letters are entitled to very little weight. So in the case of support letters offered when somebody's being accused or there's a statement of issues, what can we do to this particular point to make sure that it's included in the memo, for example, that the letter writer or author is aware of the underlying misconduct that's giving rise to a discipline case before a state board?
Talking about letters,
But the
from,
memos that, yes, the memos often include, well, as a mitigating factor, this person has character letters.
correct. And we
I'm
usually
sorry.
don't attach those letters themselves.
Yeah, correct.
But we, it really can vary from case to case. Usually you have to assume, and I think properly so, that the deputy has evaluated all those letters. And the deputy is, at the end of the day, is recommending the settlement to the board. This goes again to that tension of not trying to expose the board to more information than it maybe should see. And if, in fact, the board is ever feeling like they have not received sufficient information, or the letters are, don't provide the clarity, the board always has the ability to reject the settlement and say, let's go to hearing and see what these people actually say when they're called to testify at the hearing. So that's really the option. And the recommended adopt letters, we usually try to keep them fairly brief, so that the board has a focus on it rather than trying to, present the entire case. The accusation itself is sort of the operative document that is before the board to be settled. And so the letter, along with the accusation itself and the terms of the stipulated settlement, we believe to be the material considerations that the board needs to evaluate in order to determine whether to adopt, reject, or sometimes even come up with counter terms to, refer back to the Attorney General's office to negotiate another term, that the board wants to see included. So I know it's not necessarily an easy process. You have a lot of responsibility as board members, and you're always looking at those disciplinary guidelines. You're hearing from the agency itself, and then you need to make a determination. But if in fact, your Department of Consumer Affairs counsel can always advise you as to your options when you're given a settlement, whether to adopt it or reject it, and go to hearing. And that happens. That happens periodically.
Yeah, just one observation. Mr. Sani, sometimes I feel very frustrated looking at some of these memos because there's a difference, sometimes a departure from guidelines, and I don't have enough information to make a decision on that.
And I appreciate that. And again, that tension is what often may put you in a difficult decision-making mode. And we do not take it as a slight if in fact the board says we just don't have enough information for us to feel comfortable about a settlement, then it can reject the settlement. And the board will learn when it goes to hearing whether or not its concerns were validated by the evidence presented at the hearing or not. So, I sympathize with the task of the board. I've made many of these presentations myself in closed session to boards for many, many years. And I appreciate that it's a significant responsibility that you hold. And I think anytime there is a doubt among the board members as to whether the terms are appropriate, they have options to deal with that, as your DCA counsel will explain.
I appreciate that. And just let me close by saying this. I think more information is better. These documents are attorney-client privileged. And so I think the risk of disclosing too much is perhaps more minimal than we would think. Thank you.
Thank you. Do you have any
Thank you.
other board member comments, discussions, or questions? Seeing none, do we have any in-person public comments? Are there any public comments for individuals participating via WebEx, moderator?
All right, WebEx, now is the time to raise your hand. You can do so by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise their hand, and we will call on people in the order we have requests. We're going to take just a few seconds longer to see if we have a request for public comment. Seeing no request, you wish to continue with the agenda?
Thank you. Thank you again, Mr. Sani. Mr. Sani, we will now move on to agenda item 23B, enforcement review of statistics and trends on page 165. I will ask Ryan Blonian, Enforcement Chief, to present this agenda item.
Good morning, Board. You have received our board memo for this meeting. One of the areas I was asked to highlight, page 4, is the board ordered $421,677 in cost recovery related to our disciplinary cases. The cost recovery is the cost of our investigation, expert review services, if we have to have duplications made of x-ray films, which used to be every day, but not so common now that everything's digital. But our expenses in investigating and prosecuting the case, and of that, we've collected $385,607. So, and that just, I think, keeps us going, and it helps us fulfill the order that comes from the ALJ. I'd also like to point out that over the last couple of weeks, we've been working in Southern California on clearing some of the unlicensed dental cases that we have. And just yesterday, we had investigators out in the field looking into those. So we had a number of them that were unassigned. That number's been cut in half. And I expect that within the next couple of months, that number will be very, very low, and progress will have been made on all those cases. That's one of our biggest priorities, is ensuring people are receiving safe, clean, and sanitary dental care in adequate facilities. If you have any questions, our numbers are here. There wasn't any big swings in numbers on this memo that require additional attention today.
Yes.
Felsenfeld. Good morning, Mr. Blonian. I'm looking at just the first box of data that you have in your report, and it looks like dentists have averaged about 3,000 complaints a year. You with me on that part?
Gotcha.
And yet, in the first 6 months of this year, it looks like we're almost there.
Social media, when a person who is a dentist makes a controversial statement, pick a topic, there's about 1 million of them you could make right now that would anger somebody, and that's in the media. The trend has been it generates complaints. So if somebody is pro something or against something, the opposite side goes, oh, they're a dentist, we're filing complaints. And there's really not a lot you can do with that.
It increases your workload, though.
It does.
Thank you.
Just following up on that, and then I have another comment. Robert David, what would you follow up on from a post?
Exactly. If somebody who's pro
Yeah.
the president,
XYZ or,
people get upset, there's nothing you can do about it. And I mean, it's very, well, if this dentist is in favor of this topic, then clearly they're incapable of providing quality dental care and they should be investigated.
Okay.
It's second or third or fourth hand, and there's not anything of substance, but they can still type a report.
Okay, thank you.
Complaint down.
My other, and we've talked about this before, but this investigative case aging, that 23% of the cases are 2 to 3 years old. That I hope we're able to put some effort into clearing those, because that's the number that the legislature tears their hair out over, about licensing boards.
Yes, just this week, we hired our last vacant position, sworn investigator. Just the more bodies I have, the more we can move those cases. And there's a little bit of deception there because, complications can happen during investigations that stretch them out. And we're dealing with it, and we've been trying to be very aggressive with getting those numbers down the best we can. So we're aware of it, and hopefully with the additional staff, we can kick that down a lot.
Thank you, Chief.
I have a question, just simple question. What is the process of complaints? Can you just go over it a little bit quickly? Just what
So a
happens when you
person-
receive it? and-
Yes, a person can go online and file a complaint against anybody for anything. It's evaluated in the intake unit. And if it's a viable complaint, they'll try to collect records and have those records looked at by a dental consultant who will provide us with areas of concern that we should focus in on for the treatment. Then the case is assigned to either a special investigator or a sworn investigator. And they'll organize the file, determine what records they have, what records they may need to collect, who needs to be interviewed, and start arranging for all of that. The interviews can be slowed down because a lot of times subjects will invoke their right to counsel. And then now we not only have to work with our schedule, the dentist schedule, but the attorney's schedule. That adds time. Once the interviews are all done and the records are all there and those CB, CT scans that are so common now that make it impossible to store and transmit and be able to read is all solved, we send that to a dental expert who's now our expert witness in the case and will tell us A, B, and C were done right, but D, E, F, G were wrong. And this is why, and this is what should have been done. So we use that expert testimony in the report to move the case forward and see what next steps, a citation, AG filing. Is it something that we can just go discuss with the dentist? Something simple like record keeping that's not exactly right. So we evaluate it for that. Or is the case just a closure because the dentist didn't do anything that was outside the standard of care? And that's where most of them lie. And we close the case at that point.
How about the social media complaints? You have to go through all that process, or how do you do that? How do you
Yeah,
come up with
the-
something simple?
The social media complaints have to be all be looked at individually because you don't know if somebody has something of substance there. So they all have to be looked at manually and closed or whatever. And it takes time. And when, the CCU and IAU helped out last time, it slows everything down. And I don't know of a way to screen those with AI. I'm sure somebody will tell me there's a way, but we want to be careful and make sure we're not missing anything.
You do have to answer to each one, right?
Yes.
Yes. Thank you. Any other board questions?
Hi, Board Member Vader Hobley. So there's the data that shows a stark difference between Northern and Southern California. So do you feel there's a need to rebalance resources?
We've done that a little bit, just because we have such a vast area in Northern California. We go from Oregon border to about the northern LA County line and the ocean to Nevada. And our population isn't equal to the population down south. So we took a little bit of that southern area. It used to end at Bakersfield basically, but we took a little bit more and we're trying to help out. They also have a few more sworn investigators down there to help out. But you're right, the data it's in line with the population. Yeah.
Any other board question? No? Okay, any person comments? Any public comments, for individuals participating on WebEx?
That's why I leave it on. Any in-person comments? Any in WebEx comments, please?
All right, WebEx, now is the time to raise your hand if you wish to make a comment. You can do that by tapping the hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take a few seconds more to see if we have a request for public comment. Seeing no request, do you wish to continue with the agenda?
Thank you. Thank you, Mr. Blunney. We'll move on to agenda item 24A, status update on pending regulations. I will ask Brant Nelson, Legislative and Regulatory Specialist, to present this agenda item.
Good morning. My name is Brant Nelson. I'm the Legislative and Regulatory Specialist for the Dental Board of California. And my memo on the status update on pending regulations begins on page 169 of your board materials. This memo addresses rulemaking packages that have moved forward in the rulemaking process since the last dental board meeting. Rulemaking packages that require board action will be presented as separate agenda items or will be presented at a future board meeting. The first one up is rulemaking to amend California Code of Regulations, Title 16, Section 1005 regarding minimum standards of infection control. The proposed text was approved by the board at its May 14th and 15th, 2025 meeting. Board staff submitted the proposed text to the Dental Hygiene Board of California for review and consideration. And at the Dental Hygiene Board meeting that took place on July 19th, 2025, the Dental Hygiene Board of California approved our board's text and thereby reached consensus. Board staff have taken the necessary steps to begin the rulemaking process, which includes drafting the necessary regulatory documents. And we are working with Regulations Counsel, Christy Shield, who you folks probably saw yesterday. And we are working with her to finalize those documents for departmental review. Moving on to the next rulemaking, we have an update to amend. There's a lot of numbers there, and me reading them all is just going to make someone fall asleep. So I'll just go ahead and summarize it as regarding applications for dentist licensure and fees. So we have a lot of changes, but as an update on this particular rulemaking, the regulations package was actually approved by the director of DCA on December 1st, 2025. And it was under review by the Business Consumer Services and Housing Agency, which is, as you know, the agency just above DCA. And although it was approved by the director, the agency did take issue with a particular part of the language. And there's a particular section called 16 CCR 1028B9 and 10. And in that, we basically, and this was something that has been approved and we put in the language in the past, where folks can have their application processed based on their immigration status. If they chose to answer yes to a set of questions. However, the agency, because of current sensitivity around immigration, it's something we want to be very sensitive about. And the board actually, we put this in there to help people who are immigrants get their application going and expedited. But the agency did not think that, in light of the current sensitivity to the whole federal government and all the things happening, that would be an appropriate thing. So we're going to look at that text and revise it and address it with a lot more sensitivity. Get it in a good place, and we should have it for your review at the next May board meeting. So we'll look at that. And I just want to emphasize that a lot of people do express their frustration to me, I think rightfully, that regulations take a long time to do. It isn't a very quick process, and it's actually technically designed to be that way. There's a lot of very careful, meticulous work that has to be done to ensure accuracy, to ensure approval. Not just by the DCA director and the agency, but also the Office of Administrative Law, which also approves and reviews these for legality. And so it does take a long time. There's a lot of public input. There's a lot of periods of open comment, but we're going to make our way through it. And that's just how these things go. So I just wanted to give that update. This item is information only. No action is requested. Thank you.
Thank you, Mr. Nelson. Do we have any board discussion? Questions?
I'd like to make just a point of information, Madam President, just to put a little bit finer point on what Brant was mentioning. In addition to somewhat of an august legislative proposal agenda that we have 3 items we'll be discussing momentarily. There is also a tremendous amount of work that goes on in the rulemaking process, and Brent described that very well. What I will also tell you is for this year, 2025, we don't have any regulatory rulemaking packages language we're presenting at this meeting for approval, but we have 5 regulatory packages and language that will be coming before the board this year. That regulatory package is a lot. We are only outdone by the Board of Pharmacy, which I think has 9 this year. We started with 7. So what we don't get done in a particular year, and Mr. Nelson is correct, once we publish and promulgate the regulations, according to the Office of Administrative Law and the Administrative Procedures Act, we have 12 months by which to get that language and those regulations approved by the Office of Administrative Law. So we have to move swiftly. So we are trying to present that information to you in a dutiful manner, but also know that, behind the scenes, if you will, Mr. Nelson kind of alluded to that, we have a rulemaking calendar that we work with, not only with the board staff, but with Ms. Shields at the department and with the agency and with the Office of Administrative Law. Because it would be foolhardy for us to drop 5 regulatory packages on the department or on the agency, given the timelines that we have. And so not only does the department and agency and the Office of Administrative Law have to review our 5, they have to review the 9 from the Board of Pharmacy, and the list goes on and on and on. So I just want the board to understand that there's a tremendous amount of work that is going on at the staff level with this. There's a lot of coordination that happens, and let's be mindful and purposeful when those regulatory packages and that language comes before the board for approval. Although we only have 5 rulemaking packages that will come before the board this year, that leaves us with only 10 for 2027. So, for example, I get a lot of questions and concerns about a dentist who wants to move to a retired status. There is no retired status that we have. It currently shows up as delinquent, meaning they don't pay, they no longer have a license, it's no longer active. It shows as delinquent. That change will require an administrative rulemaking package. So I just want everybody to know that that is on the list, but we also have to do this delicate dance of making sure that we're bringing rulemaking packages forward that at least, align with our mission of protecting the public first and foremost, and we'll take it from there. So I just wanted to provide that context in addition to the detail that Mr. Nelson provided.
Thank you. Any other board comments, questions? How about any in-person comments? Seeing none, do we have any public comments from individuals participating in WebEx?
All right, WebEx, if you'd like to make a comment on 24A as an alpha, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise a hand, and we will call on people in the order we have requests. We're going to take a few more seconds to see if we have a request for public comment. Seeing no requests, do you wish to continue with the agenda?
Thank you. Yes, we'll move on to agenda item 25A, discussion and possible action to amend business and profession codes BPC sections 1621, 1628, 1633, 1635.5, 1638.1, 1724, 1750, 1753, 1753.5, 1754.5, and 1755, and repeal BPC Section 1632.6 regarding dentistry. Page 171, Mr. Brant Nelson. Thank you.
Thank you, Madam President. The board approved several legislative proposals at its November 2024, February 2025, May 2025, and November 2025 meetings to resolve various issues stemming from the enactment of the board's Sunset Bill 1453. Unable to incorporate the proposals in a committee cleanup bill or standalone bill last year, board staff worked with California Dental Association and Assembly Member Juan Alanis to incorporate the board's legislative proposals into his Assembly Bill 873. Summary of that history of 873 can be found within the August 14, 2025 board materials. On July 14, 2025, Assembly Member Alanis pulled AB 873 from hearing and is now a 2-year bill pending in the Senate Business and Professions and Economic Development Committee. To advance the legislative proposals approved by the board, staff recommend the board sponsor a standalone board sunset cleanup bill. The legislative proposal in attachment 1 hereto seeks to pursue the board's legislative changes through a consolidated legislative vehicle. So I have a table here that shows each legislative item and the date the board approved it. And these are all the things that we are going to put into this vehicle. Board staff also proposed amending BPC section 1750.1 to correct cross-references in the dental assisting and registered dental assisting and extended functions duties that inadvertently were not updated when the other amendments were made in SB 1453. Board staff also proposed additional amendments to BPC section 1753 to clean up the RDAEF examination administration language following amendments to that section in SB 1453. And while amendments to BPC section 1754.5 and 1755 were approved by the board as set forth in the above table, these sections were subsequently revised in the effort to incorporate these changes into 873 by the board's executive committee. On February 5th, 2026, the Dental Assisting Council will review the additional amendments to clarify and implement BPC section 1750.1, 1753, 1754.5, and 1755 for potential recommendation to the board for approval. The council chair will provide an update on the council's recommendation during agenda item 8. Action requested. The board is asked to consider the proposed legislative changes comprising the board's sunset cleanup bill. The board agrees with the council's recommendation to amend BPC sections 1750.1, 1753, 1754.5, and 1755 as discussed above. The board is asked to make one of the following motions. And I am requesting, staff is requesting option 1 to support the proposed recommendation. Thank you.
Do you have any board discussion on this?
If I may, Madam Chair, just, excuse me, would also like to provide some context with regards to this agenda item. I think Mr. Nelson described it perfectly. What I have noticed in my 76 days as being executive officer of the board and doing an assessment of the pending legislation and then all of the legislative proposed language that you've approved over the last couple of years, many of it's been, a lot of that language has been approved and laid down. Some of it is contained in 2-year bills. It's in a variety of different places. Mr. Nelson is correct. From a procedural standpoint, since the board went through sunset review in 2024, and that legislation didn't take effect until January 1st of 2025, there was not an opportunity to include any necessary cleanup language that you had approved in either a Senate Business and Professions Committee bill or another vehicle. So just as a reminder, the Senate Business and Professions Committee, which is primarily responsible for all the sunset review, they share those responsibilities with the Assembly Business and Professions Committee. But the Senate Business and Professions Committee typically always authors, and it's authored by the entire committee, what they call a committee bill. And that bill is only intended to include technical, non-substantive cleanup provisions to the Business and Professions Code. There's also, sometimes it depends upon the chair. Sometimes the chair of the Senate Business and Professions Committee will also decide to author a bill to provide substantive cleanup in the Business and Professions Code. Both vehicles are intended for different purposes. We have submitted a proposal to the Senate Business and Professions Committee to include some of the provisions that are contained in this proposal that you've already approved in their Senate BNP committee bill this year, and those would be the technical, non-substantive issues. But any of the substantive issues, either things that were inadvertently omitted through sunset review or changes that we realized after the fact that we needed to operationalize our sunset review report, those would not be eligible for that bill. We also have, as I mentioned in my report yesterday, we have a new committee chair of the Senate Business and Professions Committee, Senator Wahab. She is not, as of today, she is not interested in authoring a legislative vehicle for substantive cleanup. So seeing all this coming down the pike, Our recommendation to you today is to take all of the cleanup provisions that you have approved and those that you will reaffirm today and approve today. We want to put that in one legislative vehicle. So that vehicle will contain technical, non-substantive cleanup provisions that the board has approved and also substantive cleanup provisions. We do have indication from the Senate Business and Professions Committee that of our proposal, they're willing of our proposal of 12 code sections that need cleaning up. It's almost 30 pages worth of language. They have agreed to include 4 sections of the 12. So eventually what will happen is our bill, if you approve it today, will be introduced, as I mentioned in my comments yesterday. Assemblymember Joaquin Arambula, the ER physician from Fresno, has agreed to author that legislation. So if that's approved today, look for that to be in print early next week. The bill introduction deadline is February 20th, so the clock is really ticking for us. And so that vehicle will contain all of the legislative language that's in your packet. Now, to the extent some of the provisions in the language that's in your packet is included in the Senate Business and Professions Committee bill, we will strike those provisions from our bill. So the reality is, the takeaway, the punchline here is we're trying to get kind of back to zero, if you will, with all of our cleanup language. We'd like to put it in one vehicle. We would have ownership of that vehicle. We have broad-based support from committee staff to do that. And to the extent some of those provisions will be included in the Senate Business and Professions Committee bill, great. If not, we will have a vehicle, and when we meet in May, we'll have a bill number and we'll be able to report out in more detail.
Thank you. Do we have any other board member discussion, comments? We're asked to take action on this item. Do you have a comment? Oh, yes, go ahead.
No, I'll move to support the proposed recommendation in option 1 to approve the submission to the California State Legislature, the legislative proposal in attachment 1.
Okay, so Mr. David made a motion. Do we have a second?
I'll second. Thakur.
Dr. Thakur seconded. Do we have any other comments, questions? Okay, do we have any in-person comments? Welcome.
Hello. Yes. Chukis Okai with the California Dental Association. I know I also shared at the Dental Assisting Council meeting, but just wanted to reiterate also that we are looking forward to seeing this language submitted as one package with the committee. We're also continuing to offer, stakeholder input, and especially with the 8-hour infection control course, that is a big priority for the California Dental Association's members. It's, as you know, have been a challenge for the last year, and really look forward to the language to offer this course virtually so we can make sure it's accessible and that it meets the standards of the board. So we will continue to monitor this language and give our input. Yeah, thank you.
Any other in-person comments? Moderator, do we have any, please facilitate the lines for WebEx comments.
We have at least one coming up. For WebEx, now is the time to raise your hand if you don't already have your hand up. You can do that by tapping the hand button at the bottom of the screen. Dial-in users, dial *3 to raise your hand. And our first is coming from smclearin@gmail. Hold on just a moment, please. We're sending you a request to unmute your microphone.
Yes, this is Susan McLaren from the California Dental Hygienists Association, and I support Tuka's comments about our interest in the infection control aspect of the bill. We certainly support the virtual option, but are very concerned about the time frame in which the dental assistant would need to take the course. We certainly would like to see it taken before any contact with any potentially infectious material. So we will look forward to that bill and its content. Thank you very much.
Thank you. Do we have any other WebEx comments?
There are no other requests for comment at the moment.
Okay, thank you. So any other board discussion comments before we take a vote? Mr. Deakin, Secretary, please call the roll.
Thank you. The motion is to support amendments to Business and Professions Code Section 1621, 1628, 1633, 1633.5, 1638.1, 1724, 1750.1, 1753, 1753.5, 1754.5, and 1755, and repeal Business and Professions Code Section 1632.6 regarding dentistry. I'll now take the roll. Chan?
Chan, aye.
Chan, aye. Chang?
Chang, aye.
Chang, aye. David?
David, aye.
David, aye. Deerking, aye. Gelsenfeld?
Felsenfeld, aye.
Gelsenfeld, aye. Forge?
Forge, aye.
Forge, aye. Grewal?
Grayval, aye.
Grewal, aye. Larin?
Larin, aye.
Larin, aye. Medina?
Medina, aye.
Medina, aye. Olage?
Olagi, aye.
Olage, aye. Takur?
Thakur, aye.
Takur, aye. Vader Hobley?
Vader Hobley, aye.
Vader Hobley, aye. You?
You, aye.
You, aye. The motion passes.
Thank you. There was a lot of work put into that, I know. So thank you for doing this. We're going to move on to agenda item 25B. Legislative proposal to amend BPC section 1684.5, 1741, 1750, 1750.1, and 1752.4 regarding dental auxiliaries on page 200. I'm going to ask Tina Valerie, Chief of License and Program Compliance and Dental Assisting, to present this agenda item.
Good morning, board members and council. My name's Jessica Gerlach. I'm a DAC member, and I'm going to introduce this agenda item. This agenda item provides details about the working group meetings, looking at some changes to the laws about dental assistant and registered dental assistant scope of practice listed in the table of permitted duties. Board staff recognized inconsistencies between existing statutes and regulations governing allowable dental assistant and registered dental assistant duties. In response, the council chair formed a 2-member working group on November 6, 2025. Council members Rosa Linda Olagi and myself, Jessica Gerlach, to review and recommend statutory clarifications related to DA and RDA definitions, duties, and supervision requirements. The working group met with board staff and board council on November 19th and 26th, December 3rd and 10th, 2025, to clarify statutory language, line up supervision requirements, and assess consolidating regulatory duty language into statute. Stakeholders were asked to provide feedback on the proposal. On December 16, 2025, the working group, together with board staff, board council, and stakeholders, reviewed a new draft that included all feedback. This resulted in a legislative proposal that all parties were in agreement with. The working group met again on December 17, 2025, to finalize the legislative proposal and discuss what the next steps would be. The working group believes the proposed statutory updates make the rules more consistent and clearer while prioritizing patient safety and the proper use of dental assistance. Written feedback from the CDA indicates support and alignment with the working group's interpretation of supervision and related language. With council approval, the recommendation would advance to the board for review.
Thank you for introducing this for us. And I want to say thank you to you and Dr. Olagi for assisting us with this big project. So thank you so much. I'm going to be going over some of the specific amendments that we made to this packet, and I'm going to be referring to the packet I handed out this morning, just not to the one in the board materials. The one that I handed out this morning reflects the requested changes that the DAC made yesterday. So this is the most recent version that I handed out this morning. I'm going to begin on page 1 with Business and Professions Code section 1684.5. And in this section, the occurrences of the term supervising dentist would be updated to supervising licensed dentist to conform with the newly defined term proposed to be added in Business and Professions Code 1741.
Moving into Business and Professions Code 1741 on page 2, the proposal adds terms and definitions from existing regulations into this section, along with the addition of some newly defined terms for registered dental hygienist in alternative practice and supervising licensed dentist. It also adds clarifying language to some of the definitions in subdivisions L and M on pages 3 and 4 for direct and general supervision. There were also minor changes made to these definitions to align with the Dental Hygiene Board's definitions of these terms under Business and Professions Code 1902. Additional changes in this section were to subdivision E, which is on page 2, to add additional requirements to the certificate of completion issued by dental assisting educational programs and courses, and to subdivision F to eliminate the restriction limiting a licensee to no more than 8 units of continuing education per day. Moving into Business and Professions Code 1750, subdivisions F3 and 4 on page 6. We would remove from this section we would remove these two from the section and add them to Business and Professions Code 1750.1, subdivision E, to consolidate all the allowable duties into one location. Before we move on to the next section, I'd first like to highlight that while the proposal suggests a lot of revisions were made to the next two sections, there were actually very few. However, a couple of them had a big impact, which I will go over in more detail. The first of which affects both Business and Professions Code sections 1750.1 and 1752.4. Both sections have been reordered to list the allowable duties from the highest level of supervision to the lowest. The next was the creation of a chairside supervision section to consolidate all allowable duties requiring the presence of the supervising licensed dentist at the patient's chairside while the duty is being performed. Business and Professions Code 1750.1, subdivision A on page 7, adds language from regulation section 1085 and current subdivision D into this section so that all prohibited duties are in one location. Subdivision C13 on page 8 added clarifying language to mirror the requirement and regulation in relation to the removal of periodontal dressings. Moving on to Business and Professions Code 1752.4, subdivision B1 on page 11. This clarifies the dental assisting duties that registered dental assistants are allowed to perform under direct supervision based on the changes made to new Business and Professions Code section 1750.1 subdivision C. And then subdivision C1 on page 11 clarifies the dental assisting duties that registered dental assistants are allowed to perform under general supervision based on the changes made to Business and Professions Code section 1750.1 subdivision D. Subdivision E on page 12 adds clarifying language to reflect the board's current process and assigns supervision levels to the performance of these duties. Subdivision F on page 13 adds clarifying language to reflect the board's current process. And that's everything. To wrap up, I just want to say thank you to all that contributed. We had some stakeholder groups that really helped us and supported us and contributed to making sure this was a collaborative effort. So I really appreciate everybody's support and assistance, and I'd be happy to answer any questions you may have.
Do you have any board comments?
If I may, Madam President, if I could provide some, go ahead, Mr. David. So I just wanted to provide some context on this as well. This is a much smaller bill. It's only 13 pages. But I do want to commend Tina and Christy and the team on putting this together. It was merely my second day on the job where we had our second markup meeting on this proposal. I also want to thank Ms. Gerlach and Ms. Olagi for their contributions and insights to the draft. And I want to thank the working group as well. We've had a couple of meetings with them, and I really appreciate all the help and assistance in getting us to the starting gate with regards to this proposal. Specifically for the board, I just want to tip into a little bit on some of our strategic thinking on this particular proposal. As we just talked about with the cleanup legislation, since that's been approved, watch for that to be a vehicle that will be moving this legislative year. This proposal would be something that should be presumed to be effectuated during sunset review. So you went through sunset review in 2024. We're not going to be going through sunset review again until 2028. However, you have, if you approve this, you have also will be approving other proposals, and you've previously have approved voluminous cleanup provisions. So I think it's the preference of staff. Nothing would preclude us from moving, introducing this in the legislative process and moving these changes through prior to sunset, which is what we intend to do with the cleanup proposal that you just proposed, and if approved, what we would intend to do with this proposal. If we're successful in getting our cleanup proposal done this year, what we would envision would be introducing legislation in the 2027 legislative session to effectuate the changes that are in this particular proposal. This is voluminous enough. There's many changes. There's been a lot of work, a lot of consensus, and I believe in my experience that this warrants its own standalone vehicle. So that would be the goal if the proposal is approved today.
Thank you, Mr. David.
Thank you, Robert David. So help me understand, because some of this stuff's above my pay grade. Is this considered non-substantive? So there's no scope of practice. This isn't something that's going to raise hackles in the legislature, I guess.
So the main things that we did was just kind of reorder and clarify things from regulation into statute. So right now we have allowable duties in regulation that have been there for a very long time. And the statute currently was approved more recently. But in order to make things more clear, we are moving the language that needed discussion into statute, and then with the hopes of repealing the regulations that have the allowable duties. So there was no changes made to this section other than some very minor verbiage clarification added and renumbering or reordering. So there should be no controversy if that's what you're asking.
Thank you. Any other board comments? Any in-person comments? Seeing none, do we have any comments on WebEx, Mr. Moderator?
WebEx, now is the time to raise a hand for 25B as in Bravo. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few more seconds to see if we have a request. And we have S. McLaren. Hold on just a moment, please. We're sending you a request to unmute your microphone.
Yes, this is Susan McLaren at California Dental Hygienists Association, and I just want to commend the working group for an absolutely fabulous job in doing this gargantuan task. So thank you for your effort.
Thank you. And I also want to commend Ms. Olagi and Ms. Gerlach and the staff and the council. Thank you for doing this. Now we're asked to take action on this item, so we can either approve, amend, or reject. Do we have any motion on this?
John Deeriking will move to support.
Thank you.
I second.
Who seconded? Ms. Medina. Any other comments from the board before we vote? Mr. Deeriking, please take the vote.
The motion is to support to amend sections, Business and Professions Code, section 1684.
Excuse me, one second.
Since we didn't have a motion on the table before public comment, we need to take public comment
Okay, sure.
before the vote.
We have to, after, I'm sorry, okay. So any public comment on the motion? WebEx comments on the motion?
All right, WebEx, time to raise a hand once again now that you've heard the motion. You can do that by tapping the hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a moment longer to see if we have a request for public comment. Seeing no request, you wish to continue with the motion?
Yes, thank you. Any other board comments? You can take the roll, please.
Okay, the motion is to support to amend Business and Professions Code Section 1684.5, 1741, 1750, 1750.1, 1752.1, and 1752.4 regarding dental auxiliaries. I'll now take the roll. Chan?
Chan, aye.
Chan, aye. Chang?
Chang, aye.
Chang, aye. David?
David, aye.
David, aye. Deerking? Aye. Belsenfeld?
Felsenfeld, aye.
Belsenfeld, aye. Forge?
Forge, aye.
Forge, aye. Grewal?
Grewal, aye.
Grewal, aye. Larin?
Larin, aye.
Larin, aye. Medina?
Medina, aye.
Medina, aye. Olage?
Olagi, aye.
Olage, aye. Takur?
Takur, aye.
Takur, aye. Bader Hobley?
Vader Hobley, aye.
Bader Hobley, aye. You?
You, aye.
You, aye. The motion passes.
Thank you, Mr. Secretary. We'll move on to agenda item 25C, legislative proposal to amend BPC section 1628.7, 1686, 1718.2, 1718.3 regarding probationary licenses, petitions for reinstatement, termination, or modification of penalty, and canceled licenses and permits, page 222. I'm going to ask Paige Regali, Chief Administrator of Compliance, to present this agenda item. Thank you.
Good morning, board members. Thank you, Board President. My name is Paige Regali. I'm the Chief of Administration and Compliance with the board. And today I'll be presenting agenda item 25C, which begins on page 222 of your meeting materials. There also is a discrepancy within the language in here, so the correct language should have been passed out and is available on the screen as well. This agenda item is a proposal to amend Business and Professions Code Section 1628.7, 1686, 1718.2, and 1718.3. The purpose for this proposal is to clarify the process for reinstatement petitions, which is outlined in Business BPC 1686, and to make additional non-substantive clarifying changes in the other sections, 1628.7, 1718.2, and 1718.3, to conform to the changes we're proposing for 1686. The changes proposed are outlined on pages 223 through 225 of the meeting materials and include renumbering sections, clarifying time periods for all petitions, adding new requirements for submission of fingerprints, clarifying the eligibility to submit petitions, and adding a time frame to avoid multiple petitions being submitted back to back. Adding a new subdivision D to prohibit reinstatement of scope of practice permits or certificates at the time of license reinstatement. And this would require any scope of practice permits like a general anesthesia permit, moderate sedation permit, elective facial cosmetic surgery permit to apply for and meet current application requirements after the parent license, essentially the dental license, is if it is reinstated. In alignment with our past two sunset bills, we're also proposing adding a section to establish a requirement to prove competencies for a revoked or surrendered license that has been expired 5 or more years. This will give us the authority to require clinical training and examination as conditions precedent to reinstatement if not provided as rehabilitation criteria at the time of submission of the petition. Additionally, we are also adding language in a new subdivision I to establish the abandonment of a petition for reinstatement that is granted if the petitioner fails to satisfy terms or conditions set in the order within the time frame. The changes to 1628.7 are non-substantive and outlined on page 225 of the meeting materials. The proposed changes in 1718.2 are related to fees due for past renewal and delinquency fees upon reinstatement, as well as outstanding cost recovery being paid as the new probationary terms for reinstatement. Our final proposed changes to 1718.3 are only to strike the language of reinstated, which will help distinguish the process between canceled licenses versus the reinstatement of revoked or surrendered licenses. Board staff are requesting that you review the information presented and are recommending Option 2, these options are listed on page 226 of your meeting materials. I also did want to note that the language included in the meeting materials, which you would be voting on page 4 of the proposed text or 230 of the meeting materials, there would be an additional amendment to be made, which is why we're recommending option 2, where you would strike completely paragraph 3 and then renumber little k or subdivision K to J. And I'm available for questions.
Board question, comment?
I have a clarification. This is Tara Welch, Board Counsel. So yesterday, the Dental Assisting Council did approve a recommendation with the requested revision to page 4. So what's before the board now is the final version.
Okay.
So the requested motion is on page 226 of the meeting materials, option 1. Option 1.
Any other board questions or comments? Do we have a motion?
You
And
motion,
a second?
option 1.
Dr. Yu, and second?
Chang second.
Cheng, second. Okay, do we have any in-person public comments? Do we have any in-public comments from individuals participating on WebEx? DCA moderator?
All right, WebEx, now is the time to raise your hand if you wish to make a comment on the motion. You can do that by tapping the hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few seconds to see if we have a request for public comment. Seeing no request, you wish to continue with the motion?
Thank you. Board Secretary, please call the roll.
Thank you. We have a motion and a second to support amendments to sections 1628.7, 1686, 1718.2, and 1718.3 regarding probationary licenses, petitions for reinstatement, termination, or modification of penalty, and canceled licenses and permits. I'll now take the roll. Chan?
Chan, aye.
Chan, aye. Chang?
Chang, aye.
Chang, aye. David?
David, aye.
David, aye. Deer King is aye. Belsenfeld?
Felsenfeld, aye.
Belsenfeld, aye. Forge?
Forge, aye.
Forge, aye. Graywell?
Graywell, aye.
Graywell, aye. Larin?
Larin, aye.
Larin, aye. Medina?
Medina, aye.
Medina, aye. Oglage?
Olagi, aye.
Oglage, aye. Takur?
Takur, aye.
Takur, aye. Bader Hobley?
Better will be aye.
Bader Hobley, aye. You?
You aye.
You, aye. The motion passes.
Thank you, Board Secretary. Thank you, Regali. Ms. Regali. We'll move on to agenda item 26A, 2026 tentative legislative calendar, page 232. I'm going to ask Mr. Brown Nelson to present this agenda item.
The 2026 tentative legislative calendar is being provided for information only. The calendar is compiled by the Office of the Assembly Chief Clerk and the Office of the Secretary of the Senate. And so on here, I'll just note January 5th is when they reconvened, and they have until February 20th to introduce, the last day to introduce new bills. Traditionally, there's a tendency for procrastination with our legislative officials, and there's kind of an avalanche of bills, 1 to 2,000 or so, that, well, I don't know, just kind of fall on us to review in a very short period of time. So I'll be up all night reading them. And that's just that. So if there's any questions on this, that's great, but otherwise just information only. Thank you.
Oh, you're finished? Okay. Do you have any board member discussion on this item? See none. Do we have any public in-person comment?
Yeah. Good morning. I'm Dr. Guy Atchison.
I'm a representative of California Academy of General Dentistry. And last night I did some exciting reading regarding AB 873 that I wanted to talk about a little bit, especially after Mr. Nelson's presentation about the need for clarity. Yes, ma'am.
Hi, Mr. Atchison. Are your comments better served under agenda item 26B, where they're discussing the legislation of interest? I think right now this is just the legislative calendar.
That's probably true. So I'll come back.
Okay.
Thank you.
Thank you.
Do we have any other in-person comments? PCA moderator, please open the WebEx for comments.
All right, WebEx, now is the time to comment on A. If you'd like to make a comment, tap that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a moment longer to see if we have a request for public comment. Seeing no requests, you wish to continue with the agenda?
Thank you. We are now going to take a 10-minute break, and we'll be back to see you for the next item. 10:45. Session, please. Please take your seat.
Very recently, we had to solve. I'm gonna even head over to it. So that- Yeah, I don't think I.
We'll now move on to it.
I know.
Oh, Dr. Forge is, we can't see you on the video. Are you there? Somebody's missing on WebEx. Mirela, can you see if Dr. Forge is there?
Yes.
Is she there? Yeah. Dr. Chan also? Okay.
I'm here.
Thank you.
Thank you. We're going to move on to agenda item 26, legislation of interest, page 235. Mr. Brandt?
Thank you, Madam President. During the 2025 legislative year, the Dental Board of California identified bills that would impact the board and healing arts boards in general. Board members and staff actively participated in the legislative process by communicating with legislators and their staff and taking positions on proposed legislation. Summary of the bills tracked by the board during the first year of the 2025-2026 legislative session have been compiled into the legislative summary for 2025 available on the board's website. For the 2026 legislative year, board staff continue to track bills that impact the board, the Department of Consumer Affairs, and the Healing Arts boards and their respective licensees, and all licensing boards. This memo includes information regarding each bill's status, location, date of introduction, date of last amendment, and a summary. The bills are listed in numerical order: Assembly bills, followed by Senate bills. Legislation is amended, statuses are updated, analyses are added frequently. Thus, hyperlinks are identified in blue, underlined text, and are provided throughout this document to ensure board members and the public have access to the most up-to-date information. However, the information in this memo is like a snapshot in time based on what was publicly available on January 14th, 2026. Staff will present updates on the following bills that may have a direct impact on the board for discussion and possible action at this meeting. That's listed under priority legislation for board consideration. And I'm going to go through this, just the priority legislation part. I'll tell you the bill name. I'll give you a very brief summary. And then I'll look to you guys to decide if you want to do anything or move forward. So first bill up is AB 485, Ortega, Labor Commissioner, unsatisfied judgments, non-payment of wages. This is a 2-year bill that was introduced on February 10th and was last amended on July 1st. This bill would require the board to deny a new license or permit or the renewal for employers who have a non-payment of wages judgment. As written, the Labor Commissioner would notify applicable boards and bureaus. The May meeting, the board voted to take an opposed unless amended position to clarify board action following subsequent compliance by the employer. It was also unclear how the Labor Commissioner would become aware of a license or permit submitted to the board. On May 29th, 2025, the board sent an opposed unless amended letter to Assembly Member Ortega. The bill was amended on July 1st, but the amendments do not resolve the concerns raised by the board in its opposed unless amended position. That's all the information I have for this one. We did take a position on it, so I don't think we need to do anything at this point, but I'll turn it over to the board to decide.
Do we have to go one by one?
Can we have discussion
Yeah,
on
can you-
all the bills at once?
Yeah, yeah.
We have
It's
to
better to
go.
present all the bills at once. And then we'll take questions. Thank you.
Okay, sounds good. I'll go on to the next one. AB 667. I'm probably pronouncing this wrong. Solash. Thank you. Professions and vocations, license examinations and interpreters. This bill was introduced on February 14th, last amended on September 5th, 2025. It's currently a 2-year bill. This bill would, beginning July 1st, 2026, require certain boards under the jurisdiction of the Department of Consumer Affairs to permit an applicant who cannot read, speak, or write in English to use an interpreter to interpret the English written and oral versions of the license examination if the applicant meets all other requirements for licensure. The bill was amended to remove DCA Division II Healing Arts boards, so that includes the Dental Board of California. And at the May meeting, board staff recommend monitoring to ensure the language is not added back due to examination security concerns. So as of now, the Healing Arts boards remain excluded from the bill. Board staff will continue to monitor the bill for any changes. The recommended position here from staff is to continue to watch. Moving on to AB 873, Alanis, Dentistry, Dental Assistance Infection Control Course, introduced on February 19, 2025, and last submitted on July 9, 2025. It's currently a 2-year bill. At the meeting, the board voted to take a support if amended position to include the board's additional legislative proposals to resolve 1453. Of course, as our executive officer and I have explained, we do have a vehicle standalone for this, but nonetheless, this bill is still a 2-year bill, and we're just basically watching this bill. Moving on to AB 966, Carrillo, Dental Practice Act, Foreign Dental Schools. AB 966 is a dead bill at this time. It failed to pass out of its house of origin. And so just by way of the Constitution and the rules, it is now a dead bill. So we'll move on to the next bill. AB 1130, Bierman, Dentistry Outreach and Support Program, introduced on February 20th, 2025, last submitted June 23rd, 2025. This bill would require the board to develop, implement, and maintain an outreach and support program to recruit students from underserved communities in the state to pursue education and licensure in the field of dentistry. The bill would establish duties for the board, the bill would establish duties the board would be required to carry out in that regard, including conducting at least 2 outreach activities per year focused on students from underserved communities. The bill would require the board to provide a summary of actions taken pursuant to the bill's provisions as part of its report to the legislature through the sunset review process. Board staff estimated $179,000 roughly in costs for an associate government program analyst position and travel costs to implement and maintain and support the program. And in the first budget year and in the next budget year, we estimated $159,000 for ongoing costs. While the bill's aim is appreciated, it's not clear to staff how effective this kind of outreach will be in persuading students from underserved communities to become dentists. It's not like most underserved areas have dental schools or dental employers, so it's not quite clear how this will have the desired outcomes given the cost, and it would be hard to know how effective the outreach is years down the road. The recommended position from board staff is watch. For next bill, AB 1307, Avila Frias, Licensed Dentist from Mexico Pilot Program. This is currently a 2-year bill. The bill would repeal and replace existing licensed dentists from Mexico Pilot Program and instead require the board to issue a 3-year non-renewable permit to practice dentistry to an applicant who meets specified criteria and require participants in the program to comply with specified requirements. The bill would authorize participants to be employed only by federally qualified health centers that meet specified conditions and would impose requirements at those centers. The bill would require an evaluation of the program to be commenced beginning 1 year after the program has commenced as specified and would prescribe the information to be included in that evaluation. The bill would require the costs for the program to be fully paid by funds provided by philanthropic foundations. At its May 2025 meeting, the board voted to take an oppose unless amended position on AB 1307, describing its specific concerns. Board staff met with Assembly member Avila Frias' office and the bill sponsor to address the board's concerns. Based on July 8th amendments to the bill that addressed the board's concerns, the board sent a letter on July 9th, 2025, withdrawing its oppose unless amended position. Moving on to the next bill. And on 1307, the board position is currently neutral or just watch. But I'll move on to AB 1563, the next bill. This is basically just the Budget Act. There's another bill that's part of this. This happens as part of the whole process. The California Budget Act of 2026 appropriates funds for the 26-27 fiscal year, building on Governor Newsom's budget proposal. And I have a link there to Governor Newsom's proposal, what that was, if you want to look at that. The California budget process starts with the governor's January proposal, followed by a review of the legislature analyst's office, and then leading to a legislative budget bills, Assembly and Senate versions. So this is the Assembly version here, and the Senate version is listed later. But these get negotiated in conference committees and then passed by both houses for the governor's signature by a June 15th deadline. And then there's a May revision, adjustments for revenue changes, culminating in the final budget in the fiscal year starting July 1st. So the California Budget Act of 2026 consists of SB 879 and AB 1563. It's just the initial framework. The detailed budget act will emerge after the legislative review amendments and the governor's final approval. So we're just going to watch both bills. Moving on to AB 1578, Jackson, state and local officials, anti-hate speech training. This bill requires anti-hate speech training for state and local officials. And in my reading of this would likely include board members and board staff, maybe an extended board staff. It's not quite clear. We're gonna have to see how the language develops. The primary impact would be the requirement of the board members and potentially its executive staff to undergo anti-hate speech training as specified by the new law. The exact curriculum and scope of the anti-hate training have yet to be detailed in the bill's text. The board might need to review and potentially update its internal policies, codes of conduct, and professional development programs to ensure they align with the new law's provisions regarding anti-hate speech and discrimination prevention. The recommended board position is watch on this bill. And lastly, SB 879, we kind of already mentioned that falls under the California Budget Act. That's just the Senate's version of that. And so as with the assembly version of it, we are just recommending a watch position. We'll continue to monitor as that develops. That concludes the priority legislation for board consideration. Thank you. Oh, and I should probably withdraw my thanks, which I'll give it back in a minute, but action request. If desired, the board may take one of the following actions regarding each bill. Support if amended, oppose unless amended. Alternatively, the board may take no action and designate the board's position on a bill as one of the following: watch, neutral, or none. So that's the action requested to the extent you have any, and that's all. Thank you.
Thank you, Mr. Nelson. Do we have any board discussion? Yes, Mr. David?
I'm fine with the positions. I don't know that we need to take any action. I would just like to note that, all of us are volunteers in these positions and don't oversee any staff. And so these additional trainings upon trainings, it gets a little overwhelming, and I'll just leave it at that. Thank you.
Thank you. Any other board discussion? Any in-person comments? I think AGD was first.
I won't reintroduce myself, but I'm Dr. Guy Atchison. Last night, I read the current version of AB 873, and I wanted to make some comments about it because for a 2-year bill to get this far along and the language being so confusing and unclear concerns me. I want to get my piece of paper from my chair. I'm going to be right back. So as many of you know, I've been in this room for the discussions over the last 2 years about how this bill has been developed to make up for some kerfluffles that happened with the sunset review. And my understanding about this bill, it was mainly to attend to unregistered dental assistants, specifically the ones that come in basically to learn the job on the job training. And the concern that they have an adequate education in infection control before they actually participate in working with patients. And this bill is basically, as the way it's written, is merging all infection control requirements with this specific goal. So I have a couple specific questions just as examples. My first is that it concerns paragraph 5 of this AB 873. I can read it if you want. Maybe I should. This bill would
30 seconds.
No? This bill would instead make the employer responsible for ensuring that the dental assistant has successfully completed the course in infection control on or before 60 days from the date of first employment at the dental office. The bill would also authorize the dental assistant to comply with this requirement by taking a board-approved course provided by a board-approved registered dental assisting educational program.
4 seconds.
Huh?
I'm sorry. The time's up. You can submit in writing. Any comments, please? Thank you.
Secretary?
Any other in-person comments?
I'll take it. Thank you. Appreciate it.
Good morning. Sherry Becker, representing the Alliance. Concerns with AB 873. Part of the concern is regarding the 60 days, which would be applicable to the unlicensed dental assistant to take the infection control course 60 days after employment. SB 1453, that language did pass, and it does state prior to exposure. And so the Alliance supports the language that was passed in SB 1453. The other thing also of concern in in 873 is the virtual option for the lab portion, taking away any live hands-on lab oversight also with that. So the Alliance does not support the virtual option that is being offered in place of that. So thank you.
Thank you.
Melody Randolph, also with the Alliance. And the additional item of concern on the top of page 240 of the meeting materials regarding the increase in fees for approved courses. Currently, the fee is $300. And though we recognize that is grossly insufficient to cover costs of approving these courses, to increase them to a maximum of $8,000 per course is prohibitive for these course providers to pay that much money for approval. Obviously, that fee then would be, the cost of those fees would be transferred to the students taking the course and absorbed by the students, which therefore, there's already a shortage of courses. This would really impact the availability of courses, because I know a lot of providers will choose not to apply and pay that astronomical increased fee, or pass that fee along to the students, and it's just going to make it more cost prohibitive. So we would support an increase, but a reasonable increase of the fees. Doubling them to $600 makes sense, but to go from $300 to $8,000 is egregious. Thank you.
Thank you.
Hello, Tuka Zokai, California Dental Association. Considering the language of 873 and how that may change through a new vehicle of the new dental board's cleanup language, and with the committee, if we're going to have the language continue to be the 8-hour infection control course before exposure to blood and saliva, as Sherry just mentioned in her comments, then CDA believes that is why we need that online course available and accessible, and a fully online course, because we want to be able to hire dental assistants, our teams to be able to train them in appropriate infection control, and then be able to work with it being before exposure to blood and saliva. The course needs to be accessible, especially for our rural dental clinics that may not have an in-person portion accessible to them. So I'm saying it's kind of the chicken egg scenario. We want to have the chickens and the eggs together. So if it's before exposure to blood and saliva, for the course to be accessible fully virtually. Thank you.
Thank you. Do you have any other in-person comments? DCA moderator, please open the WebEx for comments.
All right, WebEx, if you don't already have your hand up, now is the time to put it up if you'd like to make a comment.
DCA moderator.
Mic check. This is the moderator. Can you hear me?
DCA moderator.
Bear with us, WebEx.
Hello, he's asleep, I think. And like the other ones. Okay, what do we do?
He's muted.
Oh, he's muted?
You see a moderator. See if it's working.
We'll give him a minute.
Mic check, mic check. This is the moderator. Mic check. All right.
Mr. Chan, could you mention something on WebEx to see if we can hear you for an audio check?
Mic check.
Okay, we seem to be having technical difficulties with those that are on WebEx. We can see you, but we're unable to hear you. Apparently those online can hear, but we can't hear in the hearing room. All right, so here, us in the hearing room, we're going to disconnect from the WebEx and rejoin, and hopefully that'll take care of the audio issue. So please bear with us momentarily.
This is the moderator. Welcome back, room.
Thank you. Are there any in WebEx comments?
Yes, we have one. So now that we're back on track, WebEx, if you don't already have your hand up, now is the time to put it up. You can do that by tapping the hand button at the bottom of the screen. Dial in users, dial *3. And first, we're going to hear from Leslie Canham. Hold on just a moment, please. We're sending you a request to unmute your microphone. All right, Leslie, it looks like you're on a mobile device. You may need to hit the ellipses button. That's the ... in order to find your unmute. I'm going to send you another request. All right, I see you put your hand up, Leslie, but that doesn't help with the unmuting that needs to happen. I'm going to send you a third request to unmute your microphone. All right, I apologize, but we're going to need to move on. Please submit your statements in writing for the board.
Thank you. Are
Hold-
there any other
hold
WebEx
on.
comments?
Hold on, we have a new Leslie. Perhaps a second login is going to work. All right.
Okay, I think you can hear me. I'm on an airplane, so I'm going to make it really brief so that you can hear me and not all the announcements. I support Melody Randolph's comments about the fee being exorbitant for an 8-hour infection control provider. I am a standalone provider, and it would be a cost I would pass along to the assistants. And again, that would impact the workforce shortage. With that being said, I travel to outreach areas, to rural areas, to the training. So there's really no excuse not to be reaching out to the providers that do travel to the dental clinics and the offices that are in these outlying areas to get this training completed. Thank you.
Thank you. Have a safe trip. Any other in WebEx comments?
That was our only request on WebEx.
Thank you. Any other board discussion or questions? I think we're finished, Mr. Brandt, right? Thank you. We'll move on to agenda item 27, future agenda items and next meeting dates, page 252, Mr. Doherty.
Thank you, Madam President. This is a new reoccurring board agenda item. The intent is to preview upcoming items under consideration for future board meetings and to solicit input for future board meeting agenda items from not only board members, but also the public. Board staff would appreciate these suggested items to also be submitted in writing to the board before, during, or after the meeting for possible consideration. Items can be submitted via email to dentalboard@dca.ca.gov. Again, that's dentalboard@dca.ca.gov. Please indicate future board agenda item in the subject line for ease of reference. Thank you. Future board dates for the board are listed on our website, but they include May 13th and 14th. That meeting will be in Anaheim, California. August 12th and 13th. That meeting will be in Sacramento at the dental board headquarters on Evergreen. And November 5th and 6th in Sacramento, location yet to be determined. As you know, we here at the board place a high importance on increasing access to care to oral health professionals. For example, yesterday, Dr. Lorin announced that we have also reconstituted the board's 2-member Access to Care Committee. In November of 2025, the board heard a presentation by the California Department of Healthcare Access and Information, also commonly referred to as HCI, on their overall workforce development programs and healthcare cost data collection efforts. The board invited HCI back to present to the board yesterday, specifically on California state loan repayment programs and scholarship programs for oral health professionals. For the remainder of the year, board staff envision having an agenda item at each remaining board meeting for presentation on programs and or best practices that can increase access to care for oral health services and specifically dental consumers in underserved communities throughout California. To that end, board staff has invited the California Department of Healthcare Services Smile California program to come and present at a future board meeting, and they have graciously accepted that invitation. Having engaged Smile California on this topic, I understand this program's goal is to meet patients where they are by bringing mobile oral health services into their communities. My hope is that Smile California can provide the board with background on how their program was constituted, its strategic objectives, the nature of the work, and how the board and Smile California could work together in partnership going forward. Suffice it to say, Madam President, that our Access to Care Committee Chair Dr. Thakur and Committee Member Ms. Medina will have plenty to consider this year and for years to come. Thank you, Madam President, and that concludes my presentation on this agenda item.
Thank you, Mr. Doherty. Is there any board member discussion on this item?
I do have one question. He mentioned that the August meeting was the 13th and the 14th, and I'd been told by staff it had been changed to the 12th and the 13th. Is that correct?
That's correct. Yeah, we went from Thursday, Friday to Wednesday, Thursday. We were having location issues, so that's why we're going to be having a cozy meeting at the Evergreen headquarters in the hearing room.
And my other just going forward request is this room, it's difficult for those on this side to kind of be connected to the, so we either need a different room or more screens. Thank you.
Thank you. Any other board member discussion, comments? Any in-person comments? Any WebEx comments, DCA moderator?
All right, WebEx, now is the time to raise a hand on if you wish to make a comment. You can do that by tapping the hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a moment longer to see if we have a request for public comment. Seeing no requests, do you wish to continue with the agenda? Oh,
Thank you.
Hold on just a moment.
Oh, okay.
S. McLaren, bear with us just a second. We're going to send you a request to unmute your microphone.
Yes, Susan McLaren for the California Dental Hygienists Association, which thanks and applauds the dental board for asking the Department of Healthcare Access and Information for details on how they incentivize dental practices in shortage areas. However, HCI is currently doing their deep dive into the oral health workforce, including dentists, dental assistants, and dental hygienists. It is my understanding that their data will come from license renewal data. The dental board might ask HCI how it plans to track the unlicensed dental assistant population who also play an integral part in the delivery of oral care.
Thank you. Do we
There
have
are
any other WebEx comments?
There are no other requests.
Thank you, DCA moderator. At this time, we are at agenda item 28, adjournment. Thank you, moderator, board staff, and public for your assistance in today's meeting. That concludes the February 5th and 6th, 2026 quarterly dental board meeting. This meeting is adjourned. Thank you.
May I just say one thing?
Yes.
I'd like to thank staff and fellow board members. I'd also like to say, when we lose somebody in life, it's very difficult, does impact the entire community. Can we just adjourn in memory of Dr. Chan's mother?
Of course,
And
absolutely.
all
My
those we've
mother-in-law,
lost.
thank you for that.
Mother-in-law, I beg your pardon. Thank you.
Thank you for calling them. Thank you so much. We do. Thank you, Dr. Chan, for being here. Appreciate it. And thank you, Dr. Forge.
Thank you.
Thanks, everybody.
That's too easy.